Hi, I'm Christopher Burgon. I own and run Christopher Burgon Solicitors. We're a specialist litigation and commercial law firm based in London. This is the third of 3 videos, which is part of a series. The series is called 6 Steps for Majority Shareholders Who Want to Take Back Control. It's for people who are in businesses where the directors and shareholders are the same people, but one of those director shareholders has gone rogue. They're ripping off the business, taking money out of it that they're not entitled to, undermining it by possibly trading through their own business, basically undermining the business, being a real nuisance. This is how to deal with this situation. This is the 3rd video. The first video was setting out who controls a private limited company. Second video discussed how best to get the wrongdoer, the rogue, out of the business. This 3rd video is all about protecting the company. Asks the question as well, will you need an injunction? Or indeed, do you need an injunction? Protecting the business, what does that look like? Well, let's think practically. Who's in control of the bank accounts? If you've got a rogue director who's helping themselves to cash out of the business, what you need to try and do is speak to the bank to stop them doing that. If there's only 2 of you, again, that's more difficult. And you may think that you would want to move money from the company account into a separate account to protect it. That is really a very difficult thing to do, and you really should be taking legal advice and following a proper procedure before you do that, because you may yourself be accused of trying to rip off the company by taking money of its bank accounts. But nevertheless, maybe that's essential. But also other practical things. Who's in charge of the IT? Is somebody who's got an administrative control? It should be you. If it's the rogue director, then that could be very difficult, because what these people tend to do is exclude people who cause them problems. So you really need to sort out who controls the IT and the emails, and who controls the confidential information, who's got the list of clients, who controls the IP within the company. All of those are practical considerations which you must address when dealing with a rogue director, somebody undermining the company. The reality probably is, though, that this person, let's face it, they're dishonest. They've already downloaded all the useful information within the company. They've got their list of clients, they've got the IP, and they're probably misusing it. They're probably competing against your business to line their own pockets. So this is where an injunction comes in. Injunctions are court orders which generally prevent people from doing something. You can have mandatory injunctions which make people do things, but generally the courts like to draft injunctions in negative terms. And in a case where a director is competing against your business, the injunction you will want would be something along the lines of stopping that person from using any confidential information from the company that they may have, or using any intellectual property. Now, that would be a very useful order if you could obtain it, because it would stop the wealth being drained from your business and would allow you, as I say, to take back control and then deal with the rogue director, rather than having to run a million miles an hour just to keep the business afloat. How do you get an injunction? Well, you make an application to the court. You turn up with the evidence, and the evidence needs to be pretty compelling. You've got to show that you've got a good case against the director. You will say to the court, this director has been undermining the business, and we're going to bring a claim for damages against him. And as part of that claim for damages, we would like an injunction to stop him misusing the confidential information. You need to show that the claim against the director is a good prima facie case. You don't have to win the case, but you have to show that you have a good, reasonable argument. And you also have to pass what's called the balance of convenience test. So the court will look at all of the circumstances of the case, it'll look at all of your evidence, and it will make its decision based on this. In all of the circumstances, will it cause most disturbance, most inconvenience to the parties if they grant the injunction, or will it cause more disturbance, more inconvenience if they don't grant the injunction? The balance of convenience test, let me give you an example to illustrate that. We had a case a few years ago where the other side came and said, incorrectly in my view, wrongfully in my view, that if they weren't granted an injunction, then all of the data of the company would be wiped. It would be lost and deleted. And so obviously the court said, well, better to have an injunction to stop that happening than to risk that actually happening, because that would be so catastrophic for the business. So they granted the injunction because the least disturbance, the least inconvenience was caused by the injunction being granted. So happy days. You go to court, you're being ripped off, but you can go to the court, you can ask the court to stop them misusing their information, stop them acting unlawfully. All you've got to do is prove your case and pass the balance of convenience test. So let's go for an injunction. Well, fine, but before you do, I would like to say that going for an injunction is a big commitment. So you're pretty early in the case here. You have to act quickly if you want an injunction. Within weeks, if not days, of you becoming aware of what's happening, you're going to have to make an application for an injunction. You are also going to say to the court that you will pursue a claim against the director, so you're committed to this. You can go to the court without notifying the director to get the injunction as quickly as possible if that's what's required, though you should give notice if you can. The court will grant an interim injunction and will make you come back to court in a couple of weeks to review the decision. So this is a lot of work and it's pretty costly. I would say tens of thousands of pounds in fees. Also, if you are successful in getting an injunction, you will need to give, well, to persuade the court to give you an injunction, you will need to give what's called an undertaking as to damages. And that is basically an insurance policy. It says if it turns out that the court granting the injunction was the wrong thing to do, then you will pay any damages incurred by the other side. So injunctions really very useful, often essential to preserve the life of a business, but they are a big commitment to make. If you do go for an injunction though, and you're successful, it's a very powerful first move in a case. Probably will mean that this will settle in your favour much quicker than if you didn't. If that's of interest to you, if you find yourself in a very difficult position where somebody's undermining the business and you need to stop it happening straight away, you need to protect the business that you've got, we'd love to speak to you. Go to the website, press the book a meeting button. That will get you a 30-minute free conversation. You can pick the time and date from our calendar. Alternatively, drop us an email or give us a call and we'll give you a call back. We'd love to speak to you. Thanks very much.